All rise. Judge Vanderbeek Court now in session. Judge, this is case number JVB 1003, Carrera versus Carrera.
Thank you. You all may be seated. Okay, Mr. Carrera,
Yes.
you brought this case before the court. What's going on?
Yes. So I brought this case before you because I'm currently paying for extracurricular activities for our daughter.
Okay.
And it's a little bit more money than I thought it was going to be, so I would like my wife, Sheila, to reimburse me for it.
Okay. So you guys are separated?
Yes.
Okay. What type of extracurricular activities is the child involved?
So our daughter's very big into sports.
Okay.
So she plays soccer, and it's just like the cost of cleats, the cost of like gloves, because she plays goalie. It's just a lot of upkeep for me, and she makes more money than I do, so I kind of want help with it.
Today, we dive into the heart of co-parenting, where emotional responsibility meets financial reality. Mr. Curillo takes the stand with quiet resolve, presenting his side of the story. He's been solely footing the bill for his daughter's extracurriculars, from soccer cleats to goalie gloves and everything in between. Now, with expenses piling up and his ex-wife earning significantly more, he's asking for a fairer split. The judge gets straight to the point. He probes into their separation, the parenting arrangement, and the depth of their daughter's commitment to sports. Mr. Curillo admits he initially took on the costs without complaint, but what started as manageable quickly became overwhelming. Carrying the burden alone? It's no longer feasible. But this case is about more than just sports equipment. At its core, it's about fairness. It's about redefining what true co-parenting means. Shared effort, shared cost, and choices rooted in the child's best interest. Emotions are running high. The courtroom is on edge. Will Sheila take responsibility and meet her share? Or will the weight of parenthood continue to rest on just one pair of shoulders? Let's find out.
Okay. I see here, ma'am, from the tax returns that you make about $100,000 a year.
Yes, ma'am.
Okay. Child support was not previously ordered.
Yes.
Okay. So are you guys in agreement to do that? Or you don't want to pay child support? What's going on?
I don't think it's necessary. We split her 50-50. She's at my house just as much. She's with me just as much, if not more.
Your Honor, I would say that's probably an argument for her to pay me. If we're splitting 50-50, I shouldn't have to pay all of it.
That's exactly what I was getting ready to say. So you kind of like told on yourself. So you ready to move forward with the numbers?
Sure.
Okay, well, let's go ahead and get ready with the numbers. So it looks like you make, like I said, $100,000 a year. Do you work overtime, or is that regularly what you make?
No, I work overtime. But
Okay. And does that include overtime?
yes, ma'am. It's a salaried position, so it's just straight out.
Okay.
Mr. Curillo doesn't mince words. With composed clarity, he lays out the rising costs tied to his daughter's deep commitment to sports. From specialized cleats to goalie gloves and out-of-state tournaments, the expenses keep climbing, and he believes it's time his ex-wife, Sheila, starts pitching in. After all, she earns a solid six-figure salary, $100,000 a year. The judge leans in, seeking specifics on their custody arrangement. Mr. Curillo explains they split custody right down the middle, a true 50-50 its partnership. And that, he argues, is exactly why the financial load should be shared just as evenly. Equal time should mean equal responsibility, especially when one parent brings in significantly more income. With the courtroom hanging on every word, the judge begins to do what judges are tasked to do: translate emotion into equity and fairness into figures. This is no longer just about feelings. It's about what justice looks like in real terms. Tensions rise. The stakes are clear. The outcome could set a powerful precedent for how shared parenting plays out when money and responsibility collide. Stay tuned.
Got it. All right. So at $100,000 a year, I have your gross at $10,000 a month. Before I continue, who pays health insurance?
We both do.
We both.
Okay, how much do you pay?
$348 or $386.
$386.
Yeah, $386.
Okay.
And I
how
pay
much?
$200.
Okay, and you both plan on maintaining those health insurance policies?
Yes.
Yes, ma'am.
Okay, great. That way, nobody has to reimburse anybody for health insurance, but because you do carry health insurance and you're going to be ordered to pay child support, I can give you credit for the $386.
Okay.
So that brings your net down to $6,988.19, which, how many children? Just one?
Just one.
Okay, so 20% of that brings your child support obligation to $1,391.64. That should cover any expenses and anything like that, because the child is heavily involved, sounds like, in extracurricular activities, excuse me. Are there any other questions?
Nope.
You don't look happy about this. What's going on?
I just think that it's a bit of an exorbitant amount, but we discussed it in the beginning when the split happened. He agreed, and
Agreed to what amount?
none.
Oh, you're saying child support, but you do understand that as the child gets older and heavily involved in
Yes.
different activities. I wasn't done.
Oh, sorry.
Involved heavily in different activities, you understand that expenses increase.
Yes, ma'am.
Okay, and the amount of child support is based on how much money you make. Child support is based on a simple calculation. So you make $100,000 a year, that's what your child support is. I mean, if you want it to be lower, you chose the profession.
Yeah.
Okay, so if there's nothing further, you all are dismissed.
The judge doesn't waste a second, diving straight into the financials. She starts with Mr. Curillo's yearly income, factoring in overtime, and arrives at a total of $100,000. After deducting health insurance, his monthly net income is calculated at $6,988. From there, the court determines his child support obligation, $1,391.64 per month. But this figure isn't just for basic needs. The judge is clear. It's also meant to cover the increasing costs of the child's active lifestyle, including sports and extracurriculars. Even with a 50-50 custody arrangement, the judge makes a critical point. Equal parenting time doesn't erase financial responsibility. Mr. Curillo pushes back, calling the amount too high, but the judge holds firm. Child support, she reminds him, isn't based on feelings. It's based on formulas. Income drives the numbers, not emotion. She also addresses a key misunderstanding. While Mr. Curillo may have previously agreed, voluntarily, to cover these expenses alone, that informal agreement doesn't override the law. And when circumstances change, so can the terms. The judge cites Texas law, explaining that child support orders can be modified when there's a material and substantial change, such as an uptick in extracurricular costs or a shift in either parent's income. And that's the crux of this case. When one parent earns significantly more, they may be expected to shoulder a greater share. Custody defines how time is divided, not how money is. As the gavel falls, the message is clear. Child support isn't just about writing checks. It's about ensuring stability, opportunity, and fairness for the children at the center of it all. If you or someone you know is navigating a similar path, remember this. Speak up, seek clarity, and let fairness find its place in the courtroom.
I just want to go over what you all witnessed in the case of Carrera versus Carrera. So they had an existing order where no child support was ordered. Well, under Texas law, when there's been a material and substantial change in circumstance, the court can go in and review the order to determine whether or not child support should be paid. Well, you heard that dad was covering all the expenses for the child to participate in all these different activities. So it warranted mom to be able to help finance those activities for the child. So that's the reason why mom was ordered to pay child support.
Let's break down what just happened in Carrera, the case of Carrera versus Carrera. We saw a core legal principle come to life, the power of change to reshape a court order. Originally, both parents were under a standing agreement, no child support required from either side. But under Texas law, when there's been a material and substantial change in circumstances, the court has the authority to revisit and revise that order. And that's exactly what happened here. Testimony revealed a growing imbalance. Dad had been covering every expense tied to the child's extracurriculars, from sports gear to league fees and travel costs. Over time, those expenses added up, and the financial burden became too heavy for one parent to carry alone. The court recognized the shift. With rising costs and a lack of shared contribution, the judge ruled it was time for mom to start pitching in. A new child support order was issued, not as a punishment, but as a step toward fairness. This decision wasn't about blame. It was about equity. recognizing the increasing demands of raising a child and ensuring that both parents do their part to support their child's evolving needs.